We're back with the Tech Policy Grind. I'm Reema Musa, and I'm a fellow with the Internet Law and Policy Foundry, the organization where the next generation of tech law and policy professionals convene to write, think, and talk about the web, technology, and disruptive innovation. This is the Tech Policy Grind, the Foundry's podcast where we chat about what's going on in the world of tech policy. Hey everyone, welcome back to the show. So if you've been following us here for a while, or if you know me personally, you might know that for the past few months I've been living in São Paulo, Brazil, studying and interning abroad before I head back to the US to finish my last semester of law school. While I've been here, I had the opportunity to intern for a boutique law firm called VMCA Advogados. That means lawyers in Portuguese, which specializes in antitrust and data protection. A ton has been happening in the Brazilian data protection space these past couple of months, so I wanted to catch up with my bosses, Marcela Mattiuzzo and Nathalie Fragoso, partners at VMCA, to unpack everything that's been going on and give you a glimpse into how the Brazilian data protection ecosystem works. Hope you enjoy. Oi, Marcela. Oi, Nathalie. Thank you for coming on the Tech Policy Grind.
Hi, Reema. It's a pleasure.
Hey, Reema. No, thank you for having us.
And I'm really excited to get into our conversation today, which is all about updates in Brazil, where we all currently are, but is where both of you are from, to talk privacy, data protection, regulatory updates. It's especially, I think, a really exciting time to be having this conversation because there is so much going on. So I want to get right into it. And to start us off and sort of contextualize our conversation, I know some of our audience is American, but we also have listeners from all over the world. What are some of the core privacy problems that appear in Brazil in particular? So many of them are probably similar to those that are faced in any jurisdiction, but in addition to those which are a little more unique to the Brazilian context.
So, Reema, Brazil introduced its general data protection law in August 2018, outlining basic rules for the processing of personal data and establishing the National Data Protection Authority, right, to oversee its compliance. Of course, processing agents have been processing data since before that. And now they must comply with the new law, not so new anymore. And, well, those agents have varied levels of resources and also varied levels of motivation. Also, we are in a social context marked by major leaks, by a certain pattern of processing data in the public sphere, which is not so secure. And I guess it's also relevant to see that the first sanctions issued by ANPD are sanctions affecting public organs. And also, I guess we have a problem, which is the easy access of certain categories of personal data, which makes it easier, for example, for people to commit identity frauds and other acts like that. I would add maybe we are in a very unequal society and people have different levels of access to what are their rights and how to make them, how to exercise them. So I guess those would be some of the problems we are facing in Brazil right now.
Yeah, and if I may chip in just quickly, any particularity in Portuguese, in Brazilian Portuguese especially, is something that we call jabuticaba, which is a fruit that basically only exists in Brazil. So whenever we say, oh, there's a jabuticaba in Brazil, it's because it's particular to Brazil. One of those things regarding data protection and privacy, perhaps, is that our system is built in a way in which there's a very strong interaction between consumer and data protection. The issue is that currently, according to the Brazilian General Data Protection Law, our sort of GDPR, those institutions, the consumer law institutions, they can also tackle data protection issues, even though the responsibility for acting on a federal level is solely of our DPA, our Data Protection Authority, the ANPD. So that's also something that's to some extent particular about Brazil, because in many other jurisdictions, we also have discussions and challenges regarding who applies what when. But here, because the consumer law system is very, very, very decentralized in the country, and the country itself is very large, that issue becomes perhaps more, I don't know, it becomes sort of a larger issue to be tackled within the context of data protection and privacy.
So I want to dig into, naturally, you mentioned the LGPD. Let's get into that a little bit more. So this is often compared to the GDPR in Europe. How is it similar, and what are some of the key differences?
They are actually similar laws. They are similar in personal, in territorial, and material scope. They both establish its extraterritorial application. They both have these legal basis regime. I mean, what a processing agent needs in order to process data is a lawful basis, right? There are also some very similar definitions, for example, personal data, and also the special categories of personal data, and in Brazil, the sensitive data, which are data that is protected by a more strict regulation on its use. So those are some of the similarities, but there are also differences. For example, regarding data subject rights. I mean, we do not have exact the same rights, and they are not to be exercised in exactly the same manner. One example of this is the right to oppose, the right to object, and a data treatment. And also, I mean, it's important to say that we have one law to be applied by one data protection authority, which is the ANPD. And when we are talking about GDPR, we are talking about a regulation which is valid in the whole European Union and to be applied by a lot of different authorities. I guess that's also an important distinction.
Yeah.
How it applies in the territory.
I'd add one particular aspect which often comes about when we're talking to foreigners and they're trying to compare to the GDPR, because it's, you know, something everyone knows of and knows about, which is profiling. And what here in Brazil is Article 20 of the LGPD. So unlike what happens in Europe, we don't actually have in our law a definition of what profiling is. And automated decision making in Brazil has different parameters than it does in the GDPR. How so? So basically, the GDPR establishes a rule by which automated decision making that is made for specific purposes is not allowed, and it is only allowed under specific circumstances. And in Brazil, it's kind of the opposite direction. So that is something that for many companies and also for NGOs and for citizens is important to understand where Brazil stands on this particular issue. It's also something that now with the discussions focusing on AI is becoming more relevant. So it's something that, you know, I think it's one very specific aspect of the law. It's like one article, but it establishes like very different results in terms of what that exactly means for, you know, any regulated entity and also for citizens. So I think it's worth highlighting.
And Marcela, earlier you mentioned the decentralization of the Brazilian consumer protection model. And I want to sort of get an understanding of how Brazilian data protection law really fits in with that wider model, and also sort of broader different concepts and regimes within Brazil, such as Brazilian constitutional law and other areas?
Yeah, so let's try to do a brief overview so that we don't stay here for 4 hours. I think, like, generally, how does data protection legislation work in Brazil? So we have, as the GDPR does, one law that is a general law. So it applies to everything data protection. So in that sense, it's very different from what exists in the US, for instance. We have the DPA, the ANPD, which, as Nacho already mentioned, is the authority responsible for applying that legislation, and also for regulating several of the aspects of the legislation that are still, like, pending regulation, unclear, need to be further scrutinized and defined. We also have, as you said, the consumer protection system, which in theory can deal with data subjects' rights. So that is where the consumer protection in theory enters this discussion. And that system is the opposite of the DPA system because it is completely decentralized. So instead of having, like, one authority which is responsible for enforcement in the entire country, we have several authorities responsible for it. We have the public prosecutor's office. We have also what we call PROCONs, which are based on every single state in Brazil, also in some cities in Brazil. So it's a very, very decentralized system. Also, you spoke about constitutional law. There's one interesting aspect here, which is after the LGPD was approved, Brazil passed a change in the constitution. Yes, US people, it's possible to change the constitution in other countries. I know it sounds awkward. So we added a fundamental right to data protection to our constitution. So now, on top of, like, us having a specific law, we also have that as a fundamental right. So the truth is there's a lot of interaction in all of those fronts. And because actual enforcement of the law is so new, so we mentioned, right, we approved the law in 2018. There was a 2-year vacatio legis period in which the law was approved, but it wasn't in effect. And we're now in 2023, so it hasn't been a very long time. So it's hard to say how exactly, though, all of those agents will interact concretely. But what we've seen so far is that the DPA is at least open to talking to other authorities and to trying to build cooperation and building a framework in which there's, like, some level of integration and not complete chaos, which, it's better than the opposite. So I'm hopeful.
It's worthy mentioning or adding that we have two specific legislations, right? One regarding the consumer relations and the other one regarding data protection. Those laws, for example, when you're talking about LGPD, we do have an organ which is responsible for interpreting it. But this law can and should be applied by, for example, the Brazilian courts. And the Brazilian courts also apply the consumer code. So those specific legislations both have to be interpreted in order to say the law to specific cases, to, establish concrete obligations and determine, some kind of reparations to data subjects. So those specific legal grounds, those specific legislations must be, although they may be interpreted by their the main organs in those systems, they also must come together in specific cases, in concrete cases. So that's when these fragmented order juridical system comes together and they form what we here have as a data protection framework.
I want to focus first on the ANPD. What's their sort of jurisdiction to focus on enforcing data protection, and what has it done so far?
The National Data Protection Authority, the Brazilian DPA, is an organ which is linked to the Ministry of Justice nowadays, and its primary role is to interpret LGPD and establish rules and guidelines for its implementation, and also sanction the processing agents when they are not compliant, when they breach the law. So the NPD, it operates both in federal, state, and municipal levels because it's one authority for the whole country, and it must interpret, it must regulate, it must implement LGPD, and also sanction the agents which are processing personal data in Brazil. So that's its main mission, the scope of its work. I guess what we can, and ANPD has been doing a lot. It has been issuing a lot of regulations. For example, ANPD, for example, has issued a regulation on the procedure for sanctioning agents. It has also kind of clarified how some aspects of the law should be interpreted by processing agents. Has also kind of issued some guidelines for, I don't know, processing agents who are still in the process of adapting its practices and establishing a compliance protocol. So ANPD has, for now, in these first years of its work, has tried to educate, I guess, the different processing agents and regulating this infra-legal level its own proceedings, its own decision-making processes, and so on.
Yeah, and what has just sort of like, it's a, I don't know, 5-month period, if that much. What has just started is actually the sanctioning process within the DPA. So we have a very limited number of cases so far. So it's really hard to say anything in terms of like what is your conclusion about what the ANPD has done? Because it hasn't done much. The truth is that it hasn't done much. But that was to some extent expected due to how the process was carried out throughout the last couple of years. So what do we have from information that we could say is that there has been a particular focus on public institutions and not only private institutions. So the ANPD has sanctioned government authorities saying, okay, you shouldn't have done this, you have to change this procedure, which is, again, to some extent, perhaps particular about Brazil. But there's a lot still that can happen there. And it's hard to say, like, okay, how is the fine range looking like? What is the DPA considering to be a problem? How is it, going about determining what is an infraction and what isn't? Because we have that specificity about the LGPD. There's no list of infringements. So you can, it's a question in itself, like what will the DPA decide that it should sanction and what will it decide that is not necessarily an infringement? So there's a lot to be done still, but as Nancy was saying, they have been heavily investing on the regulatory part of their work. Right now, for instance, they're discussing the quote unquote DPO rules in Brazil. It's a public consultation is already open. There will be a public hearing as well in early December. So, it's a very exciting time for data protection in Brazil. There's a lot that is going on.
And I want to dig in a little bit more on these different public comment and public hearing processes that the ANPD is engaging in. And they've issued a couple in the past, and as you mentioned, they have a couple ongoing now. So some of these notably are issued in both Portuguese and in English. So does that tell us anything from your point of view on whether the ANPD is really looking outward for collaboration from other data protection entities or other DPAs abroad, or if it's interested in extraterritorial enforcement, or perhaps both.
Yes, it for sure is interested, and you can see that from other initiatives they have been doing in being involved in the international data protection privacy landscape. That's obviously true. At the same time, like the one consultation that was drafted in both English and Portuguese is specific about the artificial intelligence sandbox. And we can talk more about it specifically later. But my point is that there are several other consultations that have not been released in English. So if someone that is, I don't know, outside of Brazil wants to contribute to it, the person either has to speak Portuguese, which is a little bit unlikely, or they have to do the work of translating it themselves. But I also think that, I mean, it's strategic, right? So there are issues that they want to keep like focused on Brazil, but there are other issues that they do see, a benefit of reaching out to other members of this community. That the same thing goes for like the international transfers consultation, right? So that's obviously one aspect in which you should be, listening to the global community, not just listening to Brazil. So I think they've been good at balancing that. It's clear that they do care about the international community. They want to hear them. They're participating. They're taking part also in seminars and discussions, like every year in the global privacy seminar from the AIPP in DC. There's always someone from the DPA over there. So my guess is like, sure, they are concerned about it. They want to discuss it more with the international community. At the same time, they also are concerned about not opening up too much of what they're doing to the international community. Otherwise, it's just a gigantic amount of comments that they have to process. And that is, of course, harder.
So I want to get into that AI and data protection sandbox process that they are currently sort of seeking comment on. And I think compared to other regimes that we've seen who are exploring regulatory sandboxes for privacy, the inclusion of AI within their comment process exploring a sandbox is particularly interesting. So could you talk a little bit about what this sandbox could do if implemented, and why, other than the obvious that it's on everyone's minds right now, why AI might be a particular priority for this ANPD?
Yeah, so I think there's a background issue here that if you just look at the consultation, you might not be able to grasp. But if you look at the whole picture, then you will understand better. There's currently a lot of discussion for the Brazilian AI Act, right? We're discussing a regulatory framework for AI in Brazil. And the DPA has been strongly advocating for it to become the regulator of the upcoming AI regulatory framework, if that framework is approved in Congress, etc. So part, and I think a very large part, like more than 50% of why they are focusing on AI and the AI sandbox right now is to show that, one, they have expertise on this topic, two, there's a strong connection between data protection and AI, one that should not be ignored by legislators. So if they want to pass legislation regulating AI, they should look for the Data Protection Authority and do it together with, or at least taking into consideration, the existence of the data protection framework in Brazil. So to be totally transparent, I think that is basically the reason why this consultation exists today. But at the same time, like it's obvious that there is a strong connection between AI and data protection in general, right? And I think that the sandbox experiences that we've had in Brazil were very sectorial so far. So like financial institutions, etc. And this is a different approach, right? So it's something that in theory anyone could apply to, so long as they're using like data, personal data, and AI, which is terribly broad. So to me, to be perfectly honest, it is not completely clear what they can draft from this. But I think it's not to them either. That is why they have a public consultation, which is like, what do you think, community, that we should aim for? How should we draft this? Do you see something that is more relevant than something else? What would the scope of the sandbox be? What would the sandbox mean? So my feeling is that most of the questions that are there are genuine concerns and questions that they have. And there's no obvious, clear, defined picture that they're trying to push towards. It's more like actually trying to get contributions in order to draft this in a way that makes sense.
I guess your view, Marcela, is on point, and to I don't know, it's also relevant that this public consultation was accompanied by a study on not artificial intelligence but on sandboxes. So different options were presented there in order to people give their feedback.
And to dig a little bit into the dynamic that you described, Marcela, of the ANPD sort of staking its claim on AI as a subject and wanting to establish itself as the regulator. It's interesting because I think in the US we have a somewhat analogous situation, not just for AI, but kind of for various data protection, cybersecurity, privacy issues generally, because although the FTC is probably the most prominent by a long shot regulator of data protection issues in the US, it doesn't, because we lack a federal privacy law, it doesn't have quite the same formal mandate as the ANPD does as the data protection regulator. So there's been discussion on issues of AI and cyber from various regulators across the US. So to dig into that dynamic a little bit more, who are the different regulators within Brazil that are interested in this AI regulation piece as well? And if you had to read the tea leaves, who might come out ahead?
Yeah, so I think again, there's a broader scenario for like everything digital regulation here, and AI is part of that. I think one of the most vocal regulators that is interested in kind of like any piece that you want to give them, they're happy with, is the telecommunications agency. So Anatel has advocated for being the regulator for the fake news bill, or misinformation bill, as some people call it. They are also advocating there is a bill of law in Congress right now to be the regulator of the Brazilian Digital Markets Act. They also like made some movement regarding AI, but the AI discussion is less developed, let's call it, than the other discussion, so it hasn't been so vocal. But if you listen to the public hearings, in case you speak Portuguese, they are there saying that, and there are other people, broadcasting sort of the same view. So if I were to name one that is certainly willing, I would say the telecommunications agency. I don't think they are particularly likely to become, at least in terms of AI. I think if I were to bet in between the DPA and Anatel for AI, I'd bet on the DPA. I think the main issue for the DPA is that the DPA is a very, very recent agency, right? So it hasn't even finished the LGPD process. Now it wants to take on another role, an additional role, a very complicated one. So that's a little bit hard to accommodate within government. Another that usually comes up but I think that mostly it does because it's very large and has strong capabilities generally, is the central bank. I mean, obviously, it doesn't, like, not all of AI is focused on financial institutions, but because the central bank in Brazil has, for instance, been responsible for implementing the open finance regulation and all of the interconnections between the financial institutions, etc., there is a broad view that they are capable of doing complicated stuff. They also have a good relationship with companies. That's how it's seen, at least. So that's something that makes some people more comfortable. But the truth is that I don't think there is a clear front runner for this. um, I think that the least burdensome to justify from a strictly speaking, like, legal text perspective would be the DPA, but the practical issues in the DPA are very significant. And I'm not sure, like, there would be governmental support, given that they still have so much to do in data protection itself for them to take on this new role. Um, Maybe if I were to bet, I'd say it's more likely for there to be like a council or a combinate, like a forum of, something similar to what the UK did for digital regulation. Like, oh, let's have the ICO and the CMA and a bunch of people and the Ofcom, and they're all going to do it together, at least for a certain period of time. And then when we have maturity on this topic, we can create a different authority, perhaps, to regulate this topic. When we have maturity and perhaps a little bit more budget, and people forgot about the creation of the last agency, so it's easier to create a new one. I don't know.
It's interesting to notice the different signs that an agency is interested in becoming the regulator for a specific theme. For example, in the case of AI bill, we saw ANPD providing feedback, for example, on the project and highlighting its expertise on the subject. And we also have seen Anatel making efforts to be heard in the regulation or efforts to gain some kind of foothold in the implementation of this bill of law. So it's interesting because directors come to the public and provide feedback on the proposed regulation, and also highlight the expertises and call for contributions or issue some kind of study. So it's interesting to pay attention to those different signs and when the agencies are interested in becoming a regulator or the regulator for a specific theme.
And before we start to wrap up our conversation, I want to pivot a bit because I think VMCA is such an interesting firm because not only do you have the work that you do for corporate clients on tech, data protection, and antitrust, but also this work for what would translate literally to the third sector or work with NGOs and more civil society. So I want to touch a little bit about what that work looks like in the data protection context in Brazil and sort of the overall state of surveillance and data protection from a rights perspective.
We have two main fronts. One of them is the effort to be compliant with LGPD, because every processing agent must nowadays be compliant. We do provide help to third sector organizations in becoming compliant with the data protection regulations. But there is also another very important front of our activity, which is providing guidance and help with things related to surveillance, state surveillance, and other human rights issues related to privacy and surveillance. And well, in Brazil, this is a very important topic. As we know, LGPD does not regulate law enforcement, so data protection for law enforcement is not covered by LGPD. Although nowadays the Constitution has a specific fundamental right to data protection, right? So although we don't have any specific law, we do have a constitutional protection, which is, of course, which binds, which is mandatory for all state agents, for all state activities. So right now, what we have been doing is reflecting and and giving in helping organizations navigating that data protection and privacy landscape to question some unfair practices or question some policies which have discriminatory impacts, which are disproportional, which violate the right to data protection or privacy rights. We do have in Brazil a very complicated landscape of police practices, going from the constitutional protection of telecommunications secrecy and how it is or it is not implemented, to the stop and frisk practice on the street, So there are a lot of organizations working on that, and we have been kind of providing legal support to them in order to navigate this digital landscape.
Yeah, and also I think that to some extent we've done, especially during a little bit of the Bolsonaro years, a little bit of education. So a lot of the NGOs thought that data protection could be something that would like solve their surveillance issues, their concerns with surveillance. So a little bit of it was also kind of frustrating in the sense that we said, okay, maybe not all of them, some, but not all of them. In the same sense, in the last government, there was a lot of confusion regarding our FOIA legislation and data protection. So one of the main aspects that was used to deny access to information to several of these NGOs and journalists and like the media in general was data protection, right? So they said, okay, I can't disclose this information because it's private. Therefore, I'm sorry, but now we have a new law, the LGPD, which means that I can't share anything. So there was also a process in which these people were like, is this true? Like, to which extent is this real? And to which extent is this just, something that they're hiding behind in order not to share that information? And I think the new government itself solved several of these issues. There were several. The ANPD, for instance, even signed a joint agreement with the Office of the Controller General, which is the institution in federal government that regulates our FOIA, kind of saying these two things are not, controversial. They can both exist at the same time, and you cannot simply use data protection as the one and only reason for why you cannot share any information. There's a balance here that has to be discussed and has to be reached between authorities. So a lot of the discussion was, I think, on those fronts, but there's also a lot of work still to be done. I personally see that because our DPA and our legislation does not cover any national security issues, like this is the clearest and largest front for NGOs, right? So there's a lot. Police intervention, all of that is not covered by our legislation. So obviously there's a lot to be done there by NGOs. A lot of them are seriously concerned and they're trying to do their best, and we try to help as best we can.
Because we do not have any specific legislation regarding data protection in law enforcement or national security, we do have some NGOs, for example, attempting to have this debate in the Constitutional Court. So we do have some major cases, for example, regarding some public data initiatives in the federal level, but also in the organs which deal with intelligence, and also with the sharing of data between two different public organs. Those debates, because they not all of them at least, are not covered by LGPD, have been occurring in the Constitutional Court. And it has been very interesting to accompany how the STF is addressing those challenges. Because, as we said, we do have constitutional protection to those interests, to those rights. Oh, that is the right not to be exposed to disproportional surveillance, or the right not to be, a victim of discrimination by means of surveillance and so on. And this challenge has been addressed until now by the Constitutional Court. And we are still waiting for the bill on that. It was actually presented by a commission of legal experts, but it has not been approved by the National Congress.
I think because in some ways Brazil and the US have a lot more in common than perhaps the US and the EU as far as ways that the government is set up and sort of constitutional measures and whatnot, and the fact that the US has FOIA measures and Brazil has sort of a similar thing. It's interesting to compare across and see the impact actually of having a federal data protection regime, which and actual law and regulation, which the US currently lacks, because some of those issues that you mentioned of transparency and national security tensions and whatnot have yet to be fully fleshed out, I think, because we are lacking still a federal privacy law that puts more of those tensions in sharp comparison. So that's fascinating, I think, to learn from the Brazilian context for American listeners and how these things might come to more of a head than they have so far in the American context. So to wrap us up, what does the road ahead look like from your vantage points for the Brazilian data protection landscape?
So I would expect some regulation, for example, on law enforcement, although we do not see any movement in that sense. It's something that is absolutely necessary nowadays, given the recent scandals on the use of surveillance softwares without any judicial order authorizing it, and so on. So I'd like to see some kind of regulation on that aspect, or some kind of decision by the courts, and the Constitutional Court especially, addressing this matter. But also, I guess, sector specific regulations on data protection. We have this general law, and we do have a lot of different actors trying to adapt or also regulate, interpret this general law, but in the health sector, or in the educational sector, or in the statistic sector, and so on. So I would like to see, I guess it's actually already happening, but I feel that there is a road of sector specific regulations to be worked on in the next few years.
Yeah, I also think that in any scenario, there's a lot of regulation broadly that the ANPD still has to tackle as well, from like further aspects of the LGPD that need to be further scrutinized, from literally everything, like from international transfers to data subject rights. So I think that will certainly remain. It's something that will not stop right now. But I also think that we have a challenge here for 2024, which is, will the DPA be able to like ramp up its sanctioning process? Because as much as we all believe that, it shouldn't all be about enforcing and sanctioning companies or entities, if there's no enforcement, then companies tend to like overlook data protection legislation, right? So I think that is one challenge / something that I hope to see. I think the DPA is trying to work in that direction, but it's unclear to what extent they'll be able to do that. Also, because maybe we should have said this before, but like the DPA is very small. It's very limited in human resources and in resources overall. So let's see that. We also have a new vacancy at the leadership of the ANPD right now. So one of the directors just left the authority, and it's the first of the directorships that will be filled by the new government. So I think it will be interesting to see how that process will be carried out as well. We have new changes happening because it's a new authority, like every year up until 2026, if I'm not mistaken. So that's also something that I'm looking forward to. And as Nacho already said, I don't want to like say it again, but like interaction with other authorities, both in terms of like sectorial specific regulation, but also in terms of interaction itself. Like me, I work with both, as you know, Reema, data protection and antitrust. There's a myriad of discussions there. We're just starting this process. So I think that is something that we should look out for. How will these interactions be built? I think there's a lot of room for growth there.
Thank you both so much for joining for this conversation. This has been fascinating. And also on a personal note, thank you for being such incredible hosts for my time here in Brazil, in the wonderful city of São Paulo, which is quite rapidly coming to an end, sadly. But it's been amazing getting to know you.
It was great having you.
It's our pleasure. We hope to have you back soon.
Thanks for tuning into this episode of the Tech Policy Grind. If you enjoyed the show, get in touch with us at Foundry Podcasts with an S at ilpfoundry.us, or leave us a review wherever you're tuning in. I'm Reema Musa, the host of the show, and this podcast wouldn't be possible without the help of our team at the Internet Law and Policy Foundry. Thank you to Evan Enzer for editing this episode, Lama Mohammed, our social coordinator, Allison McReynolds, our accessibility coordinator, and Tim Lorden at the Internet Education Foundation. See you next time.